Welcome again, everybody. I'm Anthony Gonzalez. I'm the program coordinator with the Higher Education Center for Alcohol and Drug Misuse Prevention Recovery. I'm joined today with my colleague, Cindy Clowner, and we want to welcome you today for our webinar titled Consistently Enforce Sanctions, Connections to the Drug-Free Schools and Community Act and Mandatory Minimum Sentences, featuring our presenter, Adam Jussel. Before we dive into today's content, I do have just a few housekeeping slides that I would like to review with everyone. Here on the screen is a screen grab of something of what your Zoom screen should look like. We do welcome your questions for our presenter today, and please feel free to submit them at any time throughout the live session. We do ask you to put them in the Q&A. The chat is an option, but please utilize the chat to introduce yourself, share where you're joining us from, any reflections or resources related to the presented content. But again, if you have specific questions today for our presenter, please provide those in the Q&A. We also have live captioning available for today, and you can enable that through that bottom dash bar as well. We also encourage everybody to learn more about becoming a member of the Higher Education Center. You can learn more about the different membership tiers and benefits of each membership by visiting our website at hecAod.osu.edu. We also encourage everybody to learn more about our upcoming virtual national meeting taking place August 2nd through the 5th. You can go to our website and view the schedule, as well as registration is open. All of the recorded sessions will go live on the Monday next week, the 26th. So of course, if you're interested in learning more, please visit our website. And with that, it is my great pleasure to introduce you today, our presenter, Adam Jussel. Adam serves as the Dean of Students for the University of Wisconsin-Milwaukee. Before UWM, Adam was the Assistant Dean of Students and Director of Student Conduct Community Standards at Washington State University. Adam received his Juris Doctorate from Seattle University and his Bachelor of Science in Business Information Systems from California Lutheran University. Thank you for being here with us, Adam, and it's my pleasure turning it over to you at this time.
Thank you, Anthony, and good afternoon, everyone. Hello again, I'm Adam Jussel, and live from Milwaukee, Wisconsin, the home of the NBA champion Milwaukee Bucks. It's been a wild week in the city of Milwaukee, so got to throw a shout out to the Bucks there while I can. Today we're going to talk about, thanks Alex, Drug-Free Schools and Communities Act, and a specific portion of the Drug-Free Schools and Community Act, which is language about consistency in enforcing sanctions. We're going to draw some parallels to criminal penalties, specifically mandatory minimum penalties nested within the Anti-Drug Abuse Act, as well as providing a series of updates about reforms and kind of where we are and how that relates to our campus. Next slide, please. So some learning outcomes today, just a brief overview. First, we're going to start, context is super important with this work. So start with the history of the Drug-Free Schools and Communities Act and the Anti-Drug Abuse Act. We're going to learn a little bit about the sanctioning requirements within the Drug-Free Schools and Communities Act, specifically the requirements that we show that we are consistently enforcing sanctions. We're going to identify areas of overlap with those mandatory minimum credit sentences, and then learn about research relating to disparities in criminal penalties. Hopefully leave some time for Q&A at the end. So with that, next slide. Wanted to start with the Anti-Drug Abuse Act. A little bit of history here. So the Anti-Drug Abuse Act of 1988, really was in 1986 that this law was passed. 1988 were a series of amendments that came shortly after the 1986 legislation. And the 1986 Act and the Anti-Drug Abuse Act was really the genesis of the war on drugs and the idea and the federal policy of a drug-free America. It created overarching federal drug-free policy goals, established the Office of National Drug Control Policy, created those mandatory minimum sentences that we'll talk about today, and also kind of established the goal of, again, a drug-free America. The 1988 amendments, one thing that's important there is that it talked about various mandatory minimum sentences relating to drug trafficking conspiracies, but it also reestablished those 1988 amendments, the federal death penalty, which had been previously revoked. The purpose of the act, again, was to strengthen federal efforts, and this is a quote from the act, in halting international drug traffic, improve enforcement of federal drug laws, and enhance interdiction of illicit drug shipments, provide a strong federal leadership in establishing drug abuse prevention and education programs, and expanded federal support for drug treatment. This was also at a time when the country was, at least one part of the country was battling alcohol abuse. This was the zenith of Mothers Against Drunk Driving. There was also a series of court cases around the late 1980s that showed that colleges and universities could be held liable for injuries and death relating to alcohol and drugs that occurred on their campus or relating to campus programs. So a lot of things going around in the late 1980s. And really kind of the point where the Anti-Drug Abuse Act and this history is really fascinating, especially given the current context. Len Bias, this is oftentimes known as the Len Bias law. Len Bias was a famous basketball player from the University of Maryland. He was thought of as being the next Michael Jordan. And he was drafted by the Boston Celtics. And on the night of his draft night, he passed away and died. Mistakenly, the thought was that he died from a crack cocaine overdose. And Boston at the time, specifically the legislators in Massachusetts, wielded a lot of power within the national federal government. And so you had this national figure that was beloved that died, what mistakenly people thought of was a crack cocaine. And within weeks, and just given the context of where we are now, it's fascinating to hear that this law was passed within weeks of his death. Congress passed the Anti-Drug Abuse Act of 1986. It is telling that the way that act passed, because it was largely bipartisan, both Democrats and Republicans supported it. It was signed by Ronald Reagan, so it's often attributed to his presidency. But it passed 92 to 16 votes in the House, and just interestingly, it passed the Senate on a voice vote. So they didn't even take roll for that vote. It was so overwhelmingly passed that they didn't need to go by senator by senator. They just took a voice vote. The mandatory minimum sentences were a late addition to the act, and they were. Joe Biden was the top Democrat on the Judiciary Committee and has been scrutinized for this because there was a working group on narcotics that rushed these mandatory minimums as a late addition into the bill. And there was really no structure or oversight built into those mandatory minimum sentences. It was literally a grid, in my mind, a grid where if you committed this type of crime, this is the mandatory minimum sentence you had. So just the media frenzy, kind of where we were as a nation, risk and liability on colleges and universities, all led to the Anti-Drug Abuse Act. Next slide, please. In the 1988 amendments of the Anti-Drug Abuse Act, there was this quote, which I won't read it out loud, but it hints at that the Congress was particularly interested on, and this is the quote, use of drugs and abuse of alcohol by students, that they constitute a grave threat to their physical and mental well-being and significantly impede the learning process. So why the Anti-Drug Abuse Act? Why am I talking about that? Well, the Anti-Drug Abuse Act created the Drug-Free Schools and Communities Act. So these two are interconnected. You can't separate one from the other. How did it do that? How did it create the Drug-Free Schools and Community Act? Excuse me. It amended the Higher Education Act of 1965. And within that, there was a drug and alcohol abuse section. And I'm going to read this. This is from the U.S. Office of the National Drug Control Policy, and this was published in 1988. Their quote is, colleges, quote, pay lip service to the war on drugs, that the 13 million students at our institutions of higher learning should know that society will not tolerate the use of drugs. And the reason that that language is important, again, is that it shows that the overarching federal policy as applied to colleges and universities was the eradication of the use of alcohol and drugs. This is the kind of the just say no preventative model. Next slide, please. Some other relevant history. The Drug-Free Schools and Communities Act, there was regulations about that act that were passed in 1990, and they are codified in the Department of Education's General Administrative Guidelines. The acronym is EDGAR. So you'll often see EDGAR part, fill in the blank, when relating to Drug-Free Schools and Communities Act work. So these regulations are really, okay, we have the Drug-Free Schools and Communities Act. It's this broad overarching legislation. Now, how do we put it into practice? These regulations are really where to go to find that information. Another thing that's important to highlight here is what's the stick? What can the federal government do if we don't comply with the Drug-Free Schools and Communities Act? Well, they explicitly say that that they can withdraw federal financial aid or any form of federal assistance. So that's one stick. And they can fine universities. And I'll talk about that a little bit later. But when we are looking to, how do we implement these programs? How do we put these into practices into place? EDGAR is a place that we often go, as well as, next slide. There are two handbooks that the Department of Education published, one in 1997 and one in 2006. Those were published by the Higher Education Center on Alcohol and Other Drug Prevention. That center was established in 1993, and it was defunded in 2012, so it no longer exists. So if you're looking for their website, it's not there. The 2006 handbook is much of the same content as the 1997 handbook, but the 2006 handbook focuses a lot more on substance abuse prevention rather than just the technical aspects of the Drug-Free Schools and Communities Act. So that's another resource that we look to in determining how to implement our Drug-Free Schools Communities Act requirements. Next slide. This is just a friendly reminder for folks that have been around. This comes as no surprise, but the major requirements of the DFSCA are the annual notification to faculty and staff and students, the biannual review, and then our prevention and enforcement mechanisms. We're going to focus today on the enforcement piece as well as the biannual review, but I do want to highlight that there are really three major requirements in the Drug-Free Schools and Communities Act. Next slide. So this consistency of enforcement of sanctions, where does that come from? Well, it comes from the requirements in the biannual review. So in the regulations, when the Department of Education is talking about the biannual review process, inside of that, it does two things. One, it says that we need to track all drug-related and alcohol-related violations, and for the purposes of studying program effectiveness. So we're tracking for the purposes of seeing, hey, does our program overall work? And if it doesn't work, we need to identify changes to that program. It also requires that we determine the number of drug-related violations on facilities, on campus facilities, or as part of our activities. And this is the language, again, ensure in our biannual review, we need to ensure that disciplinary sanctions are consistently enforced. And then we have to attach a record of our findings to that biannual review. The Department of Education, excuse me, doesn't require that we distribute the biannual review, but that we must maintain it and provide it upon request. I've seen campuses go back and forth on this, on whether they in fact distribute it or not. some campuses send it out in their annual notification or put it up on a website, so it's easily accessible to the campus community there, but it is not a requirement. Next slide. So we're going to focus now on the consistently enforced language of the regulations. The actual text from the regulation is up there, and that campuses are required to ensure that sanctions are consistently enforced. Well, the reason I mentioned handbooks earlier is that when I was searching for, well, what does that mean? What does consistent enforcement mean? It's in the 2006 handbook. And what it says is that institutions of higher education need to treat similarly situated offenders in a similar manner. So how do we do that? There's a couple different ways that the handbook says, and the first is that we need to submit a chart of sorts that basically identifies, lists each case, lists the aggravating and mitigating factors, and then identifies what the sanction was for the purposes of ensuring consistency. The other part that's important here is, as I mentioned earlier, is that we need to test out program effectiveness. And I think this is important because it hints at what does consistent enforcement mean. The 2006 handbook, when discussing effectiveness, it says a couple different things about what that means. It says that we need to design our programs on a thorough needs assessment of objective data. We need to establish measurable goals and objectives linked to identified needs. We need to implement prevention activities that are based on research or evaluation. And we need to use evaluation to refine, improve, and strengthen our program. So when it talks about program effectiveness, it's really saying this needs to be data-driven. It needs to be research-based. It can't just be anecdotal. And it needs to be objective, which makes sense intuitively. Back in 2013, when Penn State was undergoing a significant audit by the Department of Education, most of it focused on Title IX and Clery and VAWA. But within there, they made two findings relating to the Drug-Free Schools and Communities Act, which hints at the department's kind of mindset is, that these things are all connected. It's not just one area of compliance that is connected to the other, but alcohol and drug prevention is connected to sexual assault, sexual misconduct prevention, which is connected to Clery, crime reporting. So they came in, they did this very holistic review after the Joe Paterno scandal. And in there, when speaking about effectiveness, they said Penn State must describe the research methods and data analysis tools that will be used to determine the effectiveness of their program. So they got to talk about how are we going to determine whether, you got to talk about in your buy-in review, how are we going to determine whether our program is effective or not? And then actually collect the data and show how you made that determination and how you've teased out weaknesses within that. The other thing that report said is that the biennial report must address how the university will ensure consistency of its enforcement of disciplinary sanctions. So again, the focus today, how do we do that? How do we show that it's consistently enforced? One thing while we're here is that consistently enforced language has no legislative history. There's nothing significant in the congressional record that talks about, if a congressperson that was sponsoring the bill stood up and said, this is what we mean by consistently enforced. I did extensive research determining whether there was anything there, and there just really isn't, either in the regulations or in the congressional record. So what we have to go on is the handbooks, the regulation themselves. And again, the Penn State enforcement document was a really good insight, at least for me. Next slide, please. This again is from the 2006 handbook, which says that, as I mentioned earlier, one way to determine if you've treated similarly situated students in a similar manner is to submit a chart that lists each case and presents particulars of the offense, mitigating or aggravating circumstances, and the disposition. So what's the outcome? What's the sanction? And in essence, the department is saying, this is a list that allows campuses to look at and say, are we treating similarly situated students similarly? The other way that they established it, and this is from the handbook as well, is that you can document the level of effort that you've expended to detect violations, as well as the level of expertise of those who are responsible for detecting violations. So the way this might look in your biannual reviews, that you may say, here are all the RAs, here are the professional staff in our residence halls, and here's how they're trained to detect AOD related violations. And here's how they're filtered through the conduct process. That might be one way of showing this is how we detect violations. But you also can do it through looking at how do we treat students through the conduct process. So a couple different ways there. Again, these are from the 2006 handbook, and I see someone made a request, and that the link is posted in the chat for those that are interested. Next slide, please. So now we're going to circle back around to the Anti-Drug Abuse Act. So we've talked about consistency enforcement in the Drug-Free Schools and Communities Act a little bit, from the handbook, from the Penn State decision, Department of Education decision, and spend some time on mandatory minimums, what they are, what their impact is. Again, these are from the Anti-Drug Abuse Act of 1986, as well as the 1988 amendments. That act established a 5-year mandatory minimum sentence for serious drug traffickers, based on the minimum amount of drugs involved, any aggravating or mitigating factors, etc. It also established drug-free initiatives in employment, workplace, certification requirements for employers. And when we think about the campus, this isn't just students, it's employees as well, as campuses are big employers. What mandatory minimums are is that they're just a minimum number of years, typically 5 to 10 years in prison, that are served when a person is convicted of a particular crime. Again, they're mostly based on the number or the amount of drugs involved, and different drugs have different drug quantities and different drug types trigger the various minimum sentences for prison. The idea here, and this is from the legislation, was to prosecute high-level offenders. So that was the stated goal, is that Congress said, the purpose of this is not to prosecute in jail low-level offenders, it's to prosecute in jail high-level offenders, the bigger risk. The outcome of that, after years of research, and there's several entities, and we'll talk about this in a minute, that have done significant research on this, was that in 1995, for example, the US Sentencing Commission found that only 11% of drug traffickers, drug trafficking defendants, excuse me, were major traffickers. So only 11% were defendants. And there's significant other research on the sentencing ratios. So on the next slide, and don't go there yet, Anthony, there's a grid that Congress established, and because of the type of drug, one of the reasons for aggravating the sentence was crack cocaine versus powder cocaine. And why the sentencing ratio? Why did Congress, at least the stated purpose of these sentencing ratios, why did Congress pass that level of difference between the two? Well, at the time, it was thought that crack cocaine led to more significant impact on the communities that were impacted by crack cocaine, that it also led to more violent behavior. What we know now is, based on the disparities and outcomes of those convictions, is that it simply isn't true. That the sentencing ratio between crack and powder cocaine is largely a myth. It actually exists, but the purposes behind it were largely based on myth. At the time, more affluent white Caucasian people were using powder cocaine, while crack cocaine was impacting communities of color more significantly. Again, that sentencing guidelines, as I mentioned earlier, is pretty telling. Also, in the Anti-Drug Abuse Act, they established mandatory minimum penalties for marijuana violations. federal marijuana crimes. The first offense of federal conviction was generally 2 to 5 years, and the second offense was 5 to 10 years. So when we think about the federal sentencing guidelines, so the courts are guided by a couple different things. Federal courts are guided by, one, those guidelines, but also any legislation that is passed. So this would be a piece of legislation that the courts are mandated to follow. And what courts have since said in interpreting these guidelines is that if Congress establishes a mandatory minimum penalty, but that conflicts with the federal sentencing guidelines, the courts have to follow what Congress said. So effectively, courts didn't have the ability to deviate and follow the sentencing guidelines. They had to follow the Anti-Drug Abuse Act minimum sentences. So what's the impact of these mandatory minimum sentences is that 1/5 of the 2.3 million people incarcerated in the US are incarcerated for drug offenses right now. 13.4% of the US population is Black, and 26% of those arrested for drug-related offenses are Black. So a significant disparity there. There's a recent ACLU report called Cracks in the System, 20 Years of Unjust Federal Crack Cocaine Law. And it found that African Americans are 15% of this country's drug users, but there's 74% of those sentenced to prison for drug offenses. So again, highlighting the disparities of the impact of this regulation, of this law. Next slide here. And I'll post the link to that ACLU report when we're done here. This is the grid I mentioned earlier that shows the various mandatory minimum sentences established by the Anti-Drug Abuse Act. One thing to make clear here, because we've talked about consistency in enforcement and mandatory minimums, and I'm trying to draw an analog, but just to be clear for the folks here is that Congress had the opportunity to impose mandatory minimum penalties on colleges and universities, and they chose not to they use different, the plain language is different. Mandatory minimums is different than consistent enforcement. And so while we can view the two similarly because they were passed in the same one created the other, the Anti-Drug Abuse Act created the Drug-Free Schools and Communities Act, and we could draw some parallels there and be mindful of the impact. I want to be clear that consistent enforcement doesn't mean mandatory minimums. Next slide, please. So some other research that has shown the impacts of the mandatory minimum sentencing requirements is that, as I mentioned earlier, the stated goal of these mandatory minimum sentences was to punish high-level drug offenders, and that has not been the case. More than a quarter of the federal drug offenders and 2/3 of federal marijuana offenders were couriers or mules, so the lowest level trafficking roles on a culpability scale developed by the Pew Commission research on drug sentencing laws. Those defined as high-level suppliers or importers, and I mentioned this earlier, only represented 11% of the federal drug offenders. This again is from the Pew research. In 2015, that is, researchers found little relationship between the length of prison terms and recidivism rates. And that the best available data, at least in 2015, was that increased penalties for drug offenders, both at the federal and state levels, have significantly changed long-term patterns of drug availability or use. Two other things that report noted is that illegal drug prices in the time since the Anti-Drug Abuse Act were passed have declined, meaning that there is more availability, there's more opportunity to purchase illegal drugs, and that illegal drug use has increased. The share of Americans aged 12 or older in this research that said that they had used an illicit drug during the previous month increased from 6.7% in 1990 to 9.2% in 2012. And while the research notes that while an increase in marijuana helped drive that, it was more than offsetting the decline in cocaine use during that same time period. So this is research that is important when we're thinking about those mandatory minimum sentences. Next slide, please. So some reforms that are out there relating to mandatory minimum sentences. The first is the First Step Act, which was signed in 2018 by President Trump. That acronym is formally incarcerated, re-enter society, transformed, safely transitioning every person. First Step Act. What that did is that law made retroactive the reforms enacted by a Fair Sentencing Act in 2010. So there was a Fair Sentencing Act in 2010 that reduced the disparity that I mentioned earlier in sentences for crack cocaine versus powder cocaine. It reduced it. There was 100 to 1, and the Fair Sentencing Act lowered that. The First Step Act made that retroactive. So it said to folks that had been already convicted that they could petition to have their sentence reduced based on the Fair Sentencing Act of 2010, that previously they couldn't do that. It also created processes, what they call the safety valve, which allowed judges to deviate from the mandatory minimum sentences if there was good cause, which previously didn't exist. It also eased the 3-strike rule that existed and expanded good time credits for drug crimes. This was just recently part of some Supreme Court litigation. The case was Terry versus United States. And what that case essentially did, and it's worthy of a read because it kind of gives a framework of what the Supreme Court is thinking about drug legislation right now, is that that this law, the First Step law, was really only applicable to low-level offenders. So they interpreted the First Step Act, specifically the retroactive provision that allowed people to petition to be resentenced, as only impacting those that had committed low-level offenses. The plaintiff in that case had committed a low-level offense, but had 3 other convictions, I believe. So the Supreme Court said, Congress, you did a bad job. Essentially, they didn't say this verbatim, but you did a bad job of writing this. If you really intended for this to impact everybody that was convicted of a drug crime and allowed them to petition to be resentenced, you would have said that. Instead, you only permitted it for low-level offenders. So in that case, the plaintiff did not prevail. The reason I said that is an interesting case to read is that Thomas and Sotomayor have a really good back and forth about the role of race in drug sentencing. And it is really telling the framework in which they apply their analysis. So it's, again, worthy of a read. The Equal Act similarly amended the 2010 Fair Sentencing Act. And what that did is that while the Fair Sentencing Act reduced the disparity ratio between crack and powder cocaine, the Equal Act, the proposal is to simply remove it. This act is not in law yet. It's Representative Bobby Scott. It's largely bipartisan. Representative Scott is the sponsor. It's largely bipartisan. Biden has supported it as recently as June of this year. So it's moving through Congress. It does give the opportunity for resentencing. And I haven't read the language specifically, but my guess is that they're taking the lessons from that Supreme Court case and applying it to this, which would allow anyone who was convicted of a drug crime that was impacted by the disparity between crack and powder cocaine to petition for a lower sentence. The other Supreme Court decision, and this will be of interest to our conversation about cannabis legislation, is actually a denial of cert. So long and short of it is that the Supreme Court doesn't take every case that goes to it. The parties have to do something called requesting cert. Certiorari is the Latin term, and courts, the Supreme Court regularly denies cert is the parlance. But sometimes the Supreme Court has what's called a shadow docket, which is essentially not the primary case that you see in the news that they're writing on, that produces these long decisions where there's a back and forth between the judges and the justices. The shadow docket is essentially that when they deny cert, sometimes they put a little Easter egg inside of it that gives a framework of how they're thinking. So I can also post this in the chat, the parties' names. I'm not going to read it out, but it's the plaintiff was standing akimbo. And this case involved a Colorado dispensary's request that they, cannabis dispensary, that they be able to avail themselves to federal tax breaks. And the court denied cert, so they didn't take it up on the merits. But Justice Thomas, in his denial of cert, said essentially really question why we have federal marijuana legislation. Why do we have a prohibition against marijuana use in this country? And his quote was, once the federal government had a comprehensive approach, but now the federal government's current approach is half in, half out, which simultaneously tolerates and forbids the local use of marijuana. Quote, this contradictory and unstable state of affairs strains the basic principles of federalism and conceals traps for the unwary. Though federal law still flatly forbids the intrastate possession, cultivation, or distribution of marijuana, the government has sent mixed signals on this. So this got a lot of headlines because obviously the court is saying we have all these various states where you cross state lines and you can use cannabis in one state, but not in the other. You can sell cannabis in one state, but not in the other. And the court essentially said, why is that? This isn't law, so it's not a decision. But you can take some cues from the Supreme Court sometimes of what might be floating through Congress. The other reform that is significant is this is going to be kind of a deep legislative piece, but in the Consolidated Appropriations Act of 2021. So this is where legislative nerds come out. But in one of the Appropriations Act, which is essentially the government giving out money, one of the changes to the federal financial aid ability was they removed the requirement that they strike the subsection that set a drug-related eligibility standard. So inside this Appropriations Act, which they're essentially saying, here's how the federal government's going to give out money, they just removed from the Higher Education Act that there was a drug-related standard. I've yet to see how that has impacted FAFSA yet, but the theory, at least there, is that it would eliminate the negative consequences relating to questions about drug convictions and federal financial aid, which is significant, even though it was buried in an Appropriations Act. Next slide, please. So talk a little bit about some cannabis legislation in addition to that Supreme Court standing akimbo case I mentioned earlier. Most recent legislation, within the last couple of years, is recreational marijuana is now allowed in Arizona, Montana, New Jersey, and South Dakota. And medical is most recently allowed in Mississippi and South Dakota. This isn't comprehensive. This is just the most recent legislation. But cannabis is now legalized in 15 states and in the District of Columbia. DC still doesn't allow sales, but it does allow use. And some of these states, what is interesting is local prosecutors have either said explicitly or at least by practice have said, we're just not going to prosecute cannabis offenses. So even though there might not be state legislation that is permitting it, there are local prosecutors and even some AGs that are saying we're just not going to prosecute it. Most recently, Senator Schumer drafted some legislation called the Cannabis Administration and Opportunity Act, which would remove cannabis from the Controlled Substances Act and de facto remove it from those mandatory minimum sentences. And interesting there is that the impact on colleges and universities, and it may take some time, would be that we would no longer have to, at least on the enforcement side, impose sanctions or have policies relating to cannabis offenses. Doesn't mean that college and university won't have them in place, but it may be more optional as opposed to now. I've seen some recent articles from students in the state of Virginia where cannabis was recently legalized, saying, well, why is the campus still imposing this that's illegal in the state? And the constant refrain is that it's still within the Controlled Substance Act, which is a federal law, and the university has to comply with federal laws. So this draft legislation would remove it from the Controlled Substance Act. The fight between the parties, essentially the Republican and Democrat parties, has to do with more of it's a tax argument at this point in time. The one side is proposing federal taxes for the purposes of giving back to the communities that were impacted by the war on drugs, specifically cannabis, the policing of cannabis and the conviction of cannabis crimes. And so this law, this draft legislation faces a pretty difficult path through the Senate. But interestingly, some Republican senators have noted that public perception on this has changed. I recently read a piece from Senator Joyce, the great state of Ohio, who is proposing and co-sponsoring a GOP plan to regulate marijuana like alcohol is regulated federally. And Senator Joyce said that that he would not be in favor of the federal tax that is proposed by Schumer, but that he would instead just allow the states to levy the taxes as they see fit. So those are through the works. I can imagine this moving really swiftly. This has since changed, even since I put this PowerPoint together. So I'm keeping my eye on what is going on with federal legislation relating to cannabis. Representative Presley, who's a Massachusetts senator, which again is interesting because the AntiDrug Abuse Act really started out of the state of Massachusetts and Boston specifically. She has co-sponsored a bill called the MORE Act, which is the Marijuana Opportunity Reinvestment and Expungement Act, which goes probably a step further, which expunges records relating to certain records related to cannabis offenses, imposes a federal sales tax, gives some portion of that sales tax back to communities that have been impacted by marijuana legislation. And so a lot of moving parts with this most recent legislation. And I'm just kind of keeping my eyes on how that's going to shake out, especially given the current context of what's going on on the Hill. Next slide, please. I don't feel like I can give one of these presentations without talking about Oregon. So Oregon has decriminalized all drugs. That's different than legalized. This is kind of what I mentioned earlier, is that they haven't explicitly said all of this is legal. They just decriminalized it, meaning that effectively you can't legally use it, but you're not going to get prosecuted for it, is what they're saying. They legalized psilocybin for some supervised therapeutic uses. And similarly, Washington, D.C. criminalized some psychedelic plants. But Oregon became the first state in the US in modern times to decriminalize all drugs. And that is significant, but is also an outlier given the consistency across the states to have not taken that far of a step yet. But Oregon is out there. Next slide, please. So what's next? Again, I want to mention that consistency and enforcement does not equal mandatory minimums. However, I hope today what you got through this was it's important to review this in all of the context and explore the parallels between the Anti-Drug Abuse Act, the Drug Free Schools and Communities Act, and just what we're doing on college campuses. One way to look at that is when we're doing our data review, when we're doing the thing that the handbook requires we do to ensure consistency enforcement, to track effectiveness of our program, can we look to make sure that there are not disparities in the system? So that is one way to go about doing that when you're doing your data review, which is required by the biannual review. It also requires, the DFSCA requires the sanction be effective. And so, one tool there as you're going back to campuses is assessing, are your sanctions effective? So those are important aspects. Again, the data review with a critical eye. That 2006 handbook, it's still very helpful. And what it says about consistency of enforcement is that we need to treat similar situated students in a similar manner. So if you take nothing else away today, when you're thinking about consistent enforcement, That's the language. Treat similar students, similar situated students in a similar manner. It's a tongue twister. Next slide, please. And with that, I got some time for some questions here. I know that I think there's some blowing up in the chat. Anthony, do you want me to just take these on my own?
I can help with addressing them.
Sure.
So what can campus professionals do to address disparity? So if they do that review and they're noticing some inconsistencies or disparities, what can they do to address that?
Sure. I think working with campus partners to identify are there reasons, are there biases baked into the system that somehow are yielding the different results? Is the disparity one of reporting? So is it more of the reports that we're getting in are not reflective of our student population, or is it the outcomes? Is it the sanctions? If it is the sanctions, then working with your student conduct office to address those, whatever that may be, to make sure that the consistency and enforcement isn't impacting students differently on the basis of their race or ethnicity or any marginalized background.
Thank you, Adam. So the Act requires if the to identify if the consequences are effective. How are you measuring effectiveness?
Yeah, so going back to that 2006 handbook, I'm gonna grab my notes here. So it requires, the Act doesn't the Act requires that the sanctions be effective. One way to do that is to do design programs and do a thorough needs assessment, and then look at recidivism rates, survey students to determine, is it changing students' minds? Is it changing behavior? Are your reporting numbers going up or down? It's simply, what I would tell our campus colleagues is that it's simply not well, if the number goes down, then it's effective, because there's a variety of reasons, but you got to really dive into the data to see whether it's effective or not. I know the NAIAA, I think I've got that acronym right, has a grid that identifies at least research-based sanctioning that kind of gives context to the current research on what are best practices. Doesn't mean that those are the only ones, but it does identify the ones that are kind of seen as best practices. The other thing to do is that if you identify needs, if you identify college aim, there you go. Thanks, Cindy. If you identify needs and you think, okay, our sanctions or our outcomes are not effective, or maybe they're effective to a point, then the biennial review is a really great opportunity to say, here's what we're going to do to make it better. That is part of a requirement in the biennial review, is to say, we've identified a need and we're going to make it better, and here's how we're going to make it better. They're really not meant to be, the biennial review is really not meant to be we're doing everything great. We're doing everything to a point and we could do it better, and here's how we could do it better.
Thanks, Adam. Could you elaborate further the difference between sentencing and sanctioning, or are these terms that are able to be used interchangeably?
So I'll put my conduct hat on. I would never use the word sentencing in a conduct space. I would use the word sanctioning because the goals of sentencing connotes a crime, and the parallels between the criminal process and the student conduct process, we should do the best we can to separate those out because the goals are different. So I would not use in a student conduct realm the word sentencing. Conduct officers aren't convicting people of crimes, they're finding people responsible for violations or not. So I would use the word sanctioning.
Thank you, Adam. So this participant is an AOD prevention specialist at Oregon State University, and they ask, what is the best way for them to approach the Drug-Free Schools and Community Act, considering the fact that our state laws are not consistent with the nation's, while keeping in mind the laws are changing rapidly. It's challenging to make sense of all of this to the students, especially students that are 21 or older.
Uh, Thank you very much for the question. I don't have a good answer for you other than when I was in Washington, um, when I was in Washington and the law was changed to allow cannabis to be legalized, it we had to reiterate to students over and over again that while it is legal in the state, it is prohibited under federal law, and that the institution is required to follow federal law in order to keep its federal funding. So I know that's not a great answer for students, especially students that are over 21 years old that can within a state legally use that and without fines or penalties. So that is the current approach, is to kind of say, well, the institution has to follow federal law, and federal law currently, while there are reforms coming and there's hints through Supreme Court rulings that there might be changes, they have not gotten to fruition yet. So I know that that's probably not a great answer to a student that is in the state or has lived in the state or is from the state, but that is the current federal requirement.
Thank you, Adam. It does look like this might be our last question. Can you clarify what the Drug-Free Schools and Community Act means by program effectiveness? Does it mean that the enforcement or sanction appears equitable based on data, or are we talking about public health program effectiveness with demonstrative behavior change outcomes?
So I say the answer is both, which it was an either or, but the answer is both. So one is that sanctions have to be consistently enforced. Consistency and enforcement means that you have to treat similarly situated students similarly. That's what the requirement of the law is. You also need to design your program to be effective. And what the Department of Education means by effective is in the 2006 handbook. So that's designing your program based on a needs assessment, based on objective data, establishing goals and objectives based on that data, implementing prevention activities and evaluations to ensure that the program is effective, and then use evaluations to refine and improve your program. So effectiveness means both in your biannual review saying our sanctions are consistently enforced, and here's how we know that. And it means we've designed our program in a way that means effective, or a program in a way that is effective. We've done a needs assessment, we've looked at the data, and we know that our program is effective because of X, Y, and Z. But we also know we have room to grow, and here's the ways we can grow.
Thank you, Adam. We did have one other question come in, so I would like to address that. They asked right now, they only see sanctions mostly for cannabis and alcohol use. Do you have any recommendations or for enforcing pills and other substances that they can't really see?
That's a great question. So if I think about it this way, is that the requirement is not that the requirement isn't that you catch, quote unquote, everybody. The requirement is that when you do have a report and a student is found responsible, that they were sanctioned consistently with other students and that's similarly situated. So it's not that that you have to catch everything, but it's that when you do, quote unquote, catch something and a student is found responsible, that they're consistently sanctioned. Now, that being said, as I mentioned earlier, one of the ways that the 2006 handbook talks about how do we show that we're tracking this stuff accurately is they do say you should identify who's responsible for determining whether violations have occurred. So RAs, conduct folks, pro staff in the residence halls, et cetera. And then identify the level of expertise for those that are responsible for detecting those violations. So they're saying that in your biannual review, you have to tell the Department of Education, the public, we've trained folks, here's how we've trained them to provide additional or detect these violations. And here's how we staffed that, essentially.
Well, thank you so much, Adam. Extend a sincere thank you for your time and effort that you put into this webinar. And thank you for sharing your contact information for our participants who, have any questions can reach out to you directly. I greatly appreciate that, Adam. I do just have a few ending housekeeping slides. Again, we would love to see all of you at the virtual national meeting taking place at the beginning of August. You can, of course, learn more about, the live sessions and the schedule by visiting our website, and we encourage you to do so. You can connect with us in multiple ways, and here's how you can do so. You can expect to see today's recording added to our website within 2 to 3 business days, and of course, we'll include the slides there and any resources that were shared during the chat. So thank you again, Adam. I greatly appreciate what was a very timely and insightful presentation, and I hope everybody has a great rest of their day. Take care, everyone.
Please reach out to me if you want to chat about this further. It's a really interesting topic. I know this is complicated. I'm happy to chat with anybody one-on-one or a group of you on campus anytime.